right, good morning. It is 10:15. I'll take this out. My name is Kevin O'Shea, and I am pleased to introduce Margo Kaminski. Professor Kaminski is an assistant professor of law at the Ohio State University Moritz College of Law. She graduated from Harvard University and Yale Law School. Professor Kaminski's research and policy work focuses on media freedom, online civil liberties, international intellectual property law, legal issues raised by AI and robotics, and surveillance. Today, she will present a talk titled Drone Videos, Surveillance or Speech. So please silent your electronic devices, but don't put them away. We want to see you tweeting the hashtag Dawn or Doom. Please join me in welcoming Ms. Kaminski.
Are we good? I'm being recorded. I have notice of being recorded. Excellent. Yeah, you'll all get why that's funny later. So in light of the Twitter conversation, I also just wanted to point out I actually do have a Twitter handle. You all are welcome to follow me and or tweet questions at me. I can respond to you after the talk. All right, so the question that I'm starting with today, and the question that I start with and most lawyers start with in their research about a new technology, is what is the new technology? This is going to look like a very different kind of question and answer than you're going to be used to probably in the fields that you work in. So from the legal perspective, the question about drones is a drone a flying vehicle, right, like an airplane, or is it a flying camera, like a flying camera, right? So if a drone falls into the flying camera category, is it like a stalker, this crazy woman who attaches GPS to her surveillance subject's car? Or is it more like a speaker? Who's that? Alfred Hitchcock. Who was Alfred Hitchcock? Right, very famous film director, so like the auteur of all film auteurs. Most of us would consider Alfred Hitchcock to be a speaker, yeah? When he creates a movie, he's speaking about something? Okay, I got nods in the audience for the record for the video. So the reason this matters is because law, in large part, when it's handling a new technology, tries to figure out what bucket it wants to put the technology in. So we have different kinds of buckets that could be relevant to drones. If a drone is a flying vehicle, if it looks like an aircraft, it's regulated by the Federal Aviation Administration, or FAA, which largely is concerned with aircraft safety. If a drone looks like your crazy neighborhood stalker, then it's going to be regulated probably by a series of privacy laws instead of being regulated by the FAA. And if the drone in some way looks like Alfred Hitchcock, then it's going to be regulated like a speaker, which means First Amendment law applies. This creates an enormous amount of what lawyers and law professors refer to as regulatory disruption. And I have nicknamed this, in the drone context, the 50-foot gap. I'll explain why in a second. So these flying cameras, or flying iPads, or flying whatever the heck you want to call them, stalkers or speakers, are disrupting legal regulatory regimes because it's causing certain regimes to collide with each other in ways that are unexpected. So we didn't think the FAA was going to be subject to free speech law until it started regulating things that look like flying cameras. There are also major places where there are gaps between regulatory regimes. So the reason I refer to this as the 50-foot gap is that there was an example around 2 or 3 weeks ago where California attempted to pass a bill that was governing trespass by drone under 350 feet. Does anybody here know the FAA model aircraft regulations? Nobody? What's the height? Somebody here definitely does. No, it's 400. So the FAA allows a hobbyist to fly a drone at 400 feet or under. The California law governed drones from 350 feet down, which left a 50-foot gap in which you could legally fly a drone from the federal regulation, but you would have been fined under the California law. So these are the kinds of messes between buckets that occur when you have a disruptive technology. So today I'm going to start by talking about drones as stalkers, or really drones as surveillance, then talk about drones as speakers and explain why the First Amendment is implicated, And then finally talk a little bit about why this issue, the stalker versus speaker issue, is actually a much bigger problem for a host of new technologies far beyond drones. I'm going to be talking about drones that are operated by private individuals and by companies. This is because while the government interest in the privacy realm is very similar when you're talking about drones that are flown by law enforcement agencies, the government doesn't have a free speech right. The government might have interests in gathering as much information about its citizens as possible, as we heard in the Bart Gellman talk yesterday, but the government doesn't have a constitutionally protected free speech right. So, not talking about government surveillance by drone, although it's really interesting and I'm happy to answer questions about it. So, the reason that drones start falling into these regulatory bucket problems is not because the drone itself is inherently a camera, it's because the drone can carry cameras. So you all probably have seen drone videos online in which they're carrying GoPros, right? Those little casual video cameras, and people are trying to film themselves doing stupid stunts or running into wildlife, et cetera, et cetera. In some cases, the wildlife is part of a couple getting married. I highly encourage you to go Google drone crashes into groom. It's really entertaining. Drones can also carry a wide variety of other kinds of sensors, such as thermal sensors. They can do thermal imaging. Near-infrared, which is used for moisture analysis in soil. So this allows people who are using drones to do precision agriculture, and much more. Law enforcement drones, I promised I wasn't going to talk about them, but here I am talking about them, have been found to carry things called stingrays, which are otherwise known as cell site simulators. A stingray pretends to be a cell phone tower so that when your phone is trying to communicate, it pings the stingray instead of pinging a cell phone tower, which allows government to both track your location and potentially intercept your calls. There's no reason why private individuals, apart from the cost and access of stingrays, couldn't do something sort of similar, except for law. So the privacy problem with drones is really a matter of taking what drones can carry, this whole host of recording equipment, a lot of which is relatively new, and combining it with where drones can carry it, which is where? Up, right? This, at least according to a lot of us, makes for new-ish privacy concerns. Not totally new privacy concerns, but privacy concerns that are different from those raised solely by your cell phone camera. And that means we're seeing a host of new privacy laws, primarily on the state level. So I want to tease out from this audience whether these actually are new concerns. What's the difference between a drone and a news helicopter, if any? Size. Yeah, drones are much smaller, this big, this big. News helicopter, much bigger. What else? One person. Cost. So what do you mean by cost? It's going to cost a lot to fly, right? Flying a drone is much less expensive, at least once you have it or you have access to a drone hobbyist. So what does that mean for the number of these things? How many news helicopters do we have versus how many drones do we have? Or much, much more, right? Which means the surveillance concern becomes different in kind, at least people like me are arguing it becomes different in kind, because you're suddenly in a world of potentially ubiquitous and persistent surveillance, as opposed to a world of occasional news helicopters. So the other thing to look at as a comparison, and again, this is law operating by analogies, is the cell phone or the camera. What's different between a drone and this? A drone can fly. So what does that let me do if I have a drone? Yeah, I can have access in a way that I wouldn't if I were using a cell phone. So the drone can go up to the third-story window. The cell phone can't, unless I'm using particular types of sense-enhancing technology. So the puzzle I've been working on for some time now is what exactly is this privacy interest that states that are creating new drone laws are trying to protect? One way of characterizing a privacy interest is to talk about the nature of the information. And this can lead you into a conversation about capturing information, the moment of capturing sensitive information. The second type of government interest is an interest not in the moment of taking the photo, but in what happens to the information after the picture is taken. There are a lot of wonderful scholars who are talking about the second one of these. And I'll point out, at least in my opinion, that the second interest in what happens to information once it's captured is not drone specific at all, right? This is actually just about data privacy, generally speaking. And so we have a serious data privacy issue in the United States. We don't have federal data privacy regulation. Let me repeat that. We don't have federal data privacy regulation. We have a complex system that mainly falls under consumer protection law and is governed by the FTC. So my interest is in prong one. What is the government interest in preventing drones or other technologies from gathering information in the first place? So one natural solution, as I suggested, is to say the government has an interest in protecting sensitive information. What's sensitive information? Give me examples. Financial security related. National security related. Okay, so the government has an interest in preventing a drone from flying over like a military facility that has confidential national security information in it. What else is sensitive? Yeah. Anything related to medical issues, stuff related to sex, stuff related to sexual orientation. It could be stuff related to, your religious practices, stuff related to what kind of group you associate with. But notice, it's really hard to define sensitive information, right? So we kind of are begging the question we come back to, if your privacy interest is protecting sensitive information, what the heck is sensitive? Yep. So that brings us to my second category of the way that governments look at information. That was perfect. Thank you for the transition. Which is you can characterize privacy as having to do with a particular location. So there's a long history in US privacy law of protecting information that's located inside a particular private place, specifically the home, right? So there, you protect people from drone surveillance that occurs in that private or secluded place. The issue with this, with just using these two types, is what doesn't get protected? Things outside the home that aren't sensitive, right? Can you think of ways in which you might have a privacy interest in things outside the home, or at least let's make this even more specific because it's not just about the home, it's about the physical building. Things outside the physical building of your home that aren't falling into the categories of inherently sensitive information. Commercial transactions, yeah, what else? Thank you. Anything you do on your side of the privacy fence. It's like I planted you. That was excellent, right? So the big issue that's driving a lot of drone legislation in states, this hypothetical came up. I was on a phone call yesterday with a government agency for 3 hours while I was driving here. I was just listening. I wasn't talking. And the big hypothetical that kept coming up as to why states are regulating against drone surveillance was, I don't want people flying over my privacy fence and watching my daughter sunbathe in my backyard. I have some problems with that as an example, but that is kind of the hypothetical that's driving this. Because if you conceive of privacy as protecting only information that's sensitive, that's not necessarily sensitive info. If you conceive of privacy as only protecting info that's in a particular private place, your backyard is not private, at least in the sense that your home is private. So this brings us to interest C, something else. How are we going to define privacy? Drones are pushing us to define privacy and information collection in new ways. So I've been saying, and I think this is a really complex but really, really important definition, that the privacy interest that state governments are trying to get at when they're governing drones is an interest in allowing an individual to dynamically manage their social accessibility over time and using either known or easily observable features of her real environment. Let's go back to that again. It's an interest that the individual has in managing accessibility over time using features of her real environment. So I didn't come up with this. This was actually, you all thought you were coming for a law lecture. This is actually a social psychiatrist or social psychologist's definition of privacy. This was devised by a social psychologist named Erwin Altman in the 1970s. And he works in the field. He's still alive. He's at University of Utah. He works in the field of environmental psychology. And what Altman observed was people use features of their physical spaces, right, including walls in their houses, windows in their houses, to manage how accessible they are to other people. If you don't have the ability to use physical things like walls, you're going to use other tactics. You're not going to change how socially accessible you want to be. You're just going to use different mechanisms. So if I lose a wall, what kind of mechanism might I use to make myself less socially accessible? I could dig a hole. So I could create another type of physical barrier. What else? Think apart from physical things. What am I going to change? So the example I use in my writing, or have used in my writing, is hypothetical law professor standing in her office to warm up for class every morning does a silly dance, right? But she's doing the silly dance knowing that she has walls and nobody's going to come and look at her. What happens if the walls suddenly can be pierced by some kind of sense-enhancing technology? You change your behavior, right? So the consequence, or Altman observed this hydraulic relationship between the physical barrier and other social mechanisms. If you lose the ability to rely on your physical environment or features of your physical environment, you're going to change other things. You're not going to change your desired level of social accessibility. So I think this is remarkably consistent with our privacy intuitions, and I'll walk you through a couple of examples. Example 1, privacy is boundary management. That is a home, okay? Take it from my, my description that little box is a home. How do you manage your social accessibility in the home? Yeah, close the front door. What about the windows? What do you do with respect to the windows? Close the curtains. Okay, what if you live in the middle of a 50-acre property? You don't need to close the curtain, right? Because there are other features of your known environment that you're relying on to boundary manage. Enter the drone and our third-story window example. How does the drone disrupt your ability to rely on your known environment? Right, so even if the drone is just carrying a camera, it's suddenly changed perspective. And so you've been relying on that 50 acres plus having your window that you can open and close, and suddenly you can't rely on that anymore. So the government interest in governing this particular situation can be twofold. One, the government can have an interest just in allowing you to be accurate in managing your social accessibility. If you're inaccurate, bad things happen, right? You're more exposed to other people than you otherwise want to be. So that interest can involve actually using law to replace features of the environment that have been lost. So for example, California has a paparazzi law that states that you can't use sense-enhancing technology to gain information you otherwise could not have achieved except for trespass, right? So if you're in California, you're a paparazzi, you use a particularly strong zoom lens, and you're able to see inside a person's home. You couldn't have done that without the sense-enhancing technology except by sneaking up to the window before, right? So they're precisely governing this first thing. Another way of governing the first issue is to require notice. So go back to your drone that's flying outside the home. How does requiring the drone to give you notice change your ability to manage your social accessibility? So the drone lets off a blaring, I'm here, I'm watching you, notice to you while you're standing inside your home. How does that change things for you? Well, it could make things worse, right? You're like, oh, I'm being watched everywhere. That'll be my prong too. But how does it change so a professor doing silly dance, what does she do? She stops doing the silly dance, right? So I changed my accessibility by accurately managing it, and I stopped doing the silly dance I don't want other people to see. I being entirely hypothetical, by the way. All right, so 2, the government can have an interest in preserving particular environments. So as you said, the idea of a drone blaring notice at you outside your window and telling you you're being watched in your home, still seems really problematic to us. It's allowed you to manage your social accessibility accurately, but it's also made you change your behavior in a place where socially we feel it's unacceptable to require people to change their behavior. So this is, Altman refers to these as genres of boundary management, right? You behave a certain way in the home, you behave a certain way in public streets that aren't occupied. There may be reasons why the government doesn't want you to chill your behavior in those particular locations. Okay, so just running through two more of these relatively quickly. How does boundary management work in the backyard, since that's our state legislator's example? How do I manage my social accessibility in my backyard in the droneless world? Yes? There's my privacy fence, right? There are actually a series of cases about privacy fences and what they have to do to actually be effective legally. In the drone world, how is that management disrupted? Yeah, it goes over the fence, right? The fence doesn't matter anymore. So if I have a law that says drones can't fly over private property to watch individuals on their private property, that's standing in for the fence that used to be the effective tool of boundary management. All right, and this one I want to talk about at a little greater length. This is a public park. What features of my environment am I using to manage my social accessibility? Known or readily observable features. Yeah, tons of space between me and another person. I can't see another person anywhere there. What else? My clothes, thank you, absolutely. So whatever I'm wearing when I'm in that environment. What else? You also, you're like a plant. I'm going to get back to that in a second. What else do I use to manage its social accessibility in the space? Lots of features of the physical environment. Trees, rocks, right? Distance. So I want to go to the clothes thing for a second, because that is really interesting. So if a drone is there, right, or actually in the clothes case, they tend to be retorting technologies people plant in public places to look up women's skirts. Sorry, it's awful, it happens, right? So there are a number of state laws that govern upskirt photography, basically photographs taken even in public places that look through or up clothing. And those laws, I argue, are also going to boundary management, because they're taking something, a feature of your environment, your clothing, that you relied on to protect your social accessibility, and they're disrupting that. And the governments have decided in various states, we have an interest in allowing people to continue to wear whatever clothing they want in public as a means of self-expression or otherwise. And so we're going to enable people to prosecute those who take those upskirt photos. Okay, so big point. Just because, after I've talked to you guys a ton about the privacy interest on the government side, just because there is an identifiable government interest, that does not mean that interest wins over other interests. Just because there's a privacy interest, that does not mean the privacy interest wins. It's crucial to figure out what that privacy interest is when you start having to weigh it against other interests, like freedom of speech. All right, so I promised you some actual law, since I am a law professor. This part, those of you who are less interested in the actual law can kind of tune out, but keep looking at me so you look like you're engaged. Basically, when we're talking about the stalker bucket for drones, the legal landscape is extraordinarily complex and really patchworky. That's a technical term. So states have a number of laws. They're state privacy tort laws. They generally don't apply to drones or to most of the behavior that we're concerned about drones doing. Intrusion upon seclusion is a common state privacy law. It exists in most states across the country, but not all. And it requires showing that somebody intruded upon the solitude or seclusion of another in a manner highly offensive to a reasonable person. Why do I highlight those terms? Well, what qualifies as solitude? What's solitude? Yeah. Okay, sitting in my lawn chair in my backyard. But people can see through my fence, right? If they come up really close to the fence. Is that really solitude? Aloneness. Okay, so if I'm sitting in my backyard with my spouse, is that solitude? Yeah. Right? What about if I'm sitting in my backyard with a party of 4 people? Is that solitude? Yeah. Maybe, in terms of legal definitions. So it becomes the solitude idea is around that privacy idea of we protect things in a particular space, right? A particular solitary space. Provides no protection whatsoever when you're not in solitude or seclusion. So it doesn't protect anything taking place in public or most things taking place in your backyard. What qualifies as highly offensive? Right. There you go. That's the sensitive information category, right? So intrusion protects sensitive information, information in particular places, doesn't cover a lot of the things that make people concerned about drones and privacy. Peeping Tom laws, I'll go through this one really quickly. These are really outdated. So they tend to govern people who peep into a house, which sounds like it should govern drones, but it requires peeping in through a window or having actually trespassed. Why don't drones always trespass? Right, they can be over your actual technical airspace, right? So they're not breaking the trespass part of this. And often it requires secrecy. So if the drone, is noticeable to the other person, then the Peeping Tom law probably not going to govern. On the federal side, it's a mess. We have wiretap laws, so the use of the stingray that I was talking about earlier, the cell site interceptor, probably governed by those. So that shows you need to look at what the drone is carrying to figure out what's governed. We have health privacy laws, but those hinge on the relationship between the person who's doing the surveilling and the person being observed. That relationship doesn't exist with respect to most drone users and drone subjects. And then we have these consumer protection laws in the Federal Trade Commission, or FTC, but those often hinge on there being a commercial relationship between the company that's making the product and the person who's using it. They don't deal with the third party, right? So if you're being observed by a drone, it's often not going to be you who's flying the drone, it's going to be your stalking neighbor, right? Okay. There's no federal drone-specific privacy law. There's a ton of other kinds of drone vehicle law at the FAA. There have been a number of proposed bills. I'm not going to bore you by going through them. I doubt any of them is actually going to get enacted, and none of them govern use of drones by private individuals to spy on other private individuals. And then there's this process that I was on the phone call for yesterday, the multi-stakeholder process at the NTIA. I'm not going to go into the acronym, where the federal government's bringing together a bunch of different stakeholders, ranging from academics to privacy policy people to drone technologists, to have a conversation about what privacy best practices should be put in place. It's not law, it's a best practices guideline. What's the potential problem with not having law and just having best practices? Nobody has to use these, right? They're just voluntary. So in drones in particular, where you have a lot of different very small users, the smaller the user is, the less likely they are to comply with the best practices. If you're a bigger user, there are norms in place, and so companies that are concerned about looking like bad actors will adopt best practices. You're a small user, you don't care about that. All right, so a number of states have enacted these drone privacy laws. I'm going to briefly talk about Texas, because it lets me transition to the other part of my talk. In Texas, as of 2013, it's illegal to use a drone to capture an image of a person or property, not just a person, also property, with intent to conduct surveillance. What's intent to conduct surveillance? I have no idea, okay? I honestly have no idea. I think neither do the Texas state legislators. It includes a number of exceptions. So the first one, I think, points to the boundary management issue in a really helpful way. There's an exception in the Texas law. You can use a drone in a public place under 8 feet with no sense-enhancing technology. How can I boundary manage against a drone that's capturing my image when it's under 8 feet in a public place and not using sense-enhancing technology? What do I crucially have in that situation? I have a shotgun. No, that was not what I was looking for. I have notice, right? I can see the darn thing. If it's above 8 feet, so it's out of the line of sight for most humans, and it's using sense-enhancing technology, suddenly I don't know if I'm being observed. So they have this loophole for places where people have constructive notice of drone use. Then there's the disastrous part of legislation, which includes specific exceptions for particular industries, including oil pipeline inspection, real estate use, and professorial use, but not for me and not for you, only for people who are Texas professors. So, what's missing? What's clearly missing? I'll tell you a story and then tell me the answer. This is a photograph taken by a drone user before this law was enacted of a Texas meatpacking plant. And it shows a river of pig's blood, that is correct, a river of pig's blood coming out of the packing plant into a public waterway. What exception is missing from the Texas statute? Activists. What else? News gatherers, right? Anybody who's trying to actually use drones to gather information for the public good, which brings us to the First Amendment. Okay, so I promised we've talked about stalkers, now we're talking about speakers. First Amendment has a long history of being in dialogue with privacy laws for very good reasons. There's a developing First Amendment right to record. It's in a number of different courts. It's coming out of cases where people take their cell phones and use them to record police behavior. So a number of different courts, for very good reason, have said there's a First Amendment right to record matters of the public interest or information about what public officials do on public property. If you take this line of cases to the next logical conclusion, however, it starts covering a heck of a lot of behavior by many people using recording technologies. So first I want to talk briefly about why we have a right to record and why it is important that we have one. There are a series of laws being passed in a number of states called ag-gag laws. That's agricultural gag laws. They prevent you from talking about the process of making your bacon. Okay? So if you are a reporter or otherwise a watchdog and you walk into a factory farm and you start recording, a number of states have made that illegal, even if you have a legal right to be there. Right? So they've given you permission to be there, but it's still illegal for you to record. So what is the First Amendment, the free speech value in being able to record what's going on in a factory farm? This might be controversial at Purdue, but yeah, was also controversial at Ohio State. What's the First Amendment value, the free speech value? Yeah. Right, does anybody know who Upton Sinclair is or was? Right, the jungle. That's the fundamental story in the United States of news gathering leading to political change, right? Upton Sinclair reported on the condition of food production. That led to the creation of the Food and Drug Administration. So if we don't allow people to report on matters of public interest, even when they're occurring on private property, we've killed an enormous amount of potentially very valuable speech and discussion. So this is one that happened in the drone context. My question for you guys reading this is, are drones being regulated here as flying vehicles, as stalkers, or as speakers? And for those of you who can't see, this is a press release from the Federal Aviation Administration creating a temporary flight restriction over Ferguson, Missouri. Okay, so they're flying vehicles. How can you tell? The Federal Aviation Administration is regulating them. Are speakers being regulated? Yeah, who are the speakers? The journalists, right? There's a flight ban on journalists flying over Ferguson. What happened in Ferguson? Riots, right? So the whole interest in the media being there was to cover public protest. So this is one of these really odd moments. This is one of the things that flagged the issue for me of drones being regulated as vehicles, but simultaneously as speakers by an agency that has no idea how to regulate speech. The FAA has no idea how to deal with the First Amendment. So I wanted to give you an example, pardon the pun, of the rubber actually hitting the road, literally, okay? Automated license plate readers, see that's the rubber and road thing, they're on cars, basically take photos of, take photos of license plates and use them to track where cars go, okay? So this is, a picture is being taken in a public space of your license plate, and then it's being collated and analyzed to figure out where your car is going. DOJ uses this technology, private companies use this technology, and contract with the DOJ and other law enforcement officials. It's similar to the drone issue because license plate readers are also an information technology / recording technology, right? They take pictures. They're also in the real physical world, so they implicate this boundary management thing. They're not occurring, between a person and their screen. And they're clearly built for tracking, right? The purpose of these is to track the location of individuals. So Utah had an automated license plate reader law that said you cannot use this technology to track individuals, and they got sued under the First Amendment. The automated license plate reader company said, we have a First Amendment right to record. This stuff is happening in public. You have no privacy interest in it. And Utah got rid of the law. So this is happening in a number of different states. It wasn't just Utah, but it's making states really reluctant to enact laws that govern recording technologies. So how do you deal with this, right? We have a right to record on the one hand that's really important for news gathering purposes. We have privacy interests on the other hand that can also be really important for freedom of expression. One way of limiting it is to limit what the right to record actually covers. So you could say, as courts have been doing so far, the right to record only applies when you're dealing with a matter of public concern. What's the problem with that? All right, so one, potentially way too broad, right? Kim Kardashian's a matter of public concern, okay? And no joke, Hulk Hogan's sex tape also considered a matter of public concern. Sorry for bringing that up. Also, it's vague, right? It has some legal background to it, but it's a relatively vague term. What else? Do you guys record things all the time that are not matters of public concern? So if this is the limit of the right to record, the government can do whatever the heck it wants in preventing you from recording things that are not matters of public concern. Does that have free speech implications? Totally, right? Like, you can't take funny photos of your friends anymore. And it's not, the other thing is it's not in keeping with actual social practice. Like, we do feel like we should have an ability to take photos of people, at least in public, regardless of whether it's a matter of public concern. So you could also, alternatively, and this is what the big hook for this conference, early last year's conference, you could limit the right to record to protecting only what's deliberately, intentionally recorded by human authors. So if your AI or your automated algorithm is recording things, or more simply, the camera that you just put up in the corner that's always on, we could say, well, that's not authored speech. That's not Hitchcock. That's not an auteur. And so that doesn't get protected. My argument against this is there's plenty that gets recorded that still has significant First Amendment values. So what can you think of that would be recorded automatically or by an AI in the near future that implicates First Amendment values, that implicates speech? C-SPAN, always on, right? Clearly important for speech purposes. Stuff that goes on that's recorded, again, inside factory farms could be always on, clearly important for speech purposes. So this implicates not just a right to speak, right, because you don't have a human speaker, but the right to receive information, the right of the public to get information that seems speech-like, and that takes us into fundamental purposes of First Amendment law. So you thought we were going to be talking about drones. We're actually going back to like major constitutional principles. Why do we have the First Amendment? Do we have it because we want to protect people who speak and the autonomy of people who speak? Do we have it because we want people to be able to better govern themselves and vote on issues they care about? Do we have it because listeners should be able to pick from a marketplace of ideas, et cetera? So disruptive technology is putting us way back into first principles. All right, so last but not least, you could limit the right to record by saying the right to record covers everything. All recording is protected except when there's privacy. What's the problem with that? We've been talking about this for like 45 minutes. It's really hard to define privacy. So if we define privacy along the lines of how people have been defining privacy, only of sensitive information or only of information in specific private places, then the right to record covers everything except those. And then we run into the ag-gag issue of there's no right to record on a private space, which clearly seems wrong with our intuitions. Okay, so without going into the details of this, my solution in talking about privacy as boundary management is to say you have to look at the privacy interest as in some way distinct from speech. So the government isn't targeting speech about a particular thing when it's trying to govern boundary management. It's also not governing pure conduct, right? It's not just governing pressing a button. It is governing something that's speech-like. But if you use boundary management as the analysis of the privacy interests, you can figure out, separate from speech, what it is that the government's actually trying to do. All right, so what ends up happening, again, super technical, don't have to go into it unless you want me to in questions, is that the speech and privacy interface for these technologies will change depending on where you are. So if you're in a private space, what do you think is going to actually be heavier on the scale? The privacy part. If you're in a public space, what's going to be heavier on the scale? The speech part. Great, you guys would all like flying colors pass my privacy class. So without looking at the actual like technical interface, which is a whole bunch of things called scrutiny, this means that in practice, in legal practice, you use a different level of scrutiny depending on where the person is actually located. Okay, and that's appropriate/okay, which is not intuitive to First Amendment people for the most part. All right, so to wrap this up, drones are definitely not the only technology that are posing these questions. We have automated license plate readers, which we saw, smart refrigerators, smart objects, Internet of Things. Why does that pose the same issues? It's recording information about you in your physical environment, potentially communicating that to third party, taking place in real world, right? Smart objects, and then smart toys. Who's that? Who's Hello Barbie? Did you guys see the enormously long New York Times article about her? Hello Barbie is AI Barbie. Mattel has actually created her. She's going to be in your home, right? If you have small girls or boys who like Barbie. So she actually does store information your child says to her so that she can have more intelligent conversations with your child later on. So again, recording technology in the physical environment in spaces that we formerly thought of as private. And then this dude. What's this dude? He's a robot, right? So it's not that far of a step from Hello Barbies to home robots. Roombas are the better example of this. Recording technology in your physical environment, disrupting traditional notions of privacy and traditional regulatory buckets. So my point is all these things are coming. The Internet of Things, robots, Hello Barbie, drones, they're all presenting this same problem of how do you weigh privacy and speech. They'll carry recording equipment. The critical differences, possibly critical differences, is most of this other technology is going to be taking place in the home, right? So we put under the magnifying glass at much greater detail the issue of what happens when you deliberately allow this to come into your formerly private space. That involves incredibly complicated issues of consent. So if I allow a person to come into my house, does that mean that I have agreed for them to record something in my house? No. If I allow, by the way, that's not necessarily the legal answer, just to let you know. If I allow, so don't allow law enforcement in your house unless you're also agreeing for them to record, just saying. That's not legal advice. Okay, so if I allow a robot to operate in my house, and I give the robot permission to geomap my house so that it doesn't bump into things, or to have a video camera running so it doesn't run into my dog, am I giving that robot permission to keep that information indefinitely and share it with third parties? So again, your intuition's not mapping on to current US privacy law, right? So this leads to more disruption, maybe of a slightly different kind, but on the same spectrum as the drone disruption. They're disrupting both privacy and speech law, forcing us to return, as I showed in the First Amendment context, to some really serious first principle questions of why we have free speech law, why we have privacy law in the first place. This makes it an incredibly exciting time to be someone like me, right? Because all these things are changing at a pace that's far faster than regulation. And so I'm going to end by thanking all of you, especially engineers, for making it possible for me to be me. Thank you.
Now we have some time for Q&A, so if you have questions, I will bring a microphone around. Any questions?
Hi, thank you for coming.
Yeah.
I'm under the impression that when protecting my privacy in my home or on my property, that I have more rights in dealing with an individual as far as how assertive I can be, say. getting someone out of my home or off of my property. And my impression is that you don't have those same rights with automated technology like drones. That you cannot, in fact, assert yourself in removing this technology. Is that a false impression, or am I?
So
onto
okay.
something?
So as a legal matter, so I'm going to distinguish the legal from the physical responses, right? As a legal matter, a human trespassing versus a drone trespassing makes no difference. The issue with drones is that trespass law becomes incredibly complicated because different states have different air right rules. So a person in Washington state versus a person in California versus a person in Texas might have different trespass requirements in terms of where the drone can't be flown to end up on your private property. So legally, you can say, that drone is trespassing, get off of my property. There are enforcement problems, right? Because if the person walks onto your property, you can have them arrested. If the drone flies through your airspace, where's the drone operator? I have no idea, right? And so there's the potential problem of traceability of trying, so that's why a lot of people are working on like drone license plate issues and drone registration. Then to the physical response, okay, the I want to take a shotgun to the drone question, which is asked surprisingly often. Aside, just quickly related to that, there was actually a town in Colorado that wanted to have not only drone hunting licenses, but also a bounty for shooting down federal drones. You can't do that, okay? That is not okay. That is destruction of federal property, et cetera. So there is, I will point you, there's a great piece by a law professor at University of Miami named Michael Frumkin, and one of his students, whose name unfortunately I forget, but he did a lot of the work on the paper, called Self-Defense Against Drones. So it's Fromkin, and he basically talks about what kinds of traps could you set to take down drones that are entering without your permission onto private property. I am not expressing an opinion on whether I think he's correct, but it's really interesting, and that's about the shotgun and the drones. Yes?
I've been a model aviator since when you had to build them yourself and they're expensive. And it seemed, I've argued with a few people on YouTube that most communities have model aviation rules. Now, the young smart kids say, oh, those are unconstitutional and stuff, but I don't understand why we can't separate the fact that the drone's got a camera with the fact that even though it's small and plastic and cheap, that you just don't fly in a public park or over a football stadium, and that's the only rule we're worried about, and keep the First Amendment out of it.
Yeah, so this is actually, this might get more technical than it needs to, but I want to try to address that. There's this weird thing that happens in the First Amendment, which is that something that doesn't look like speech, right, it just looks like aviation regulation about safety, can start looking like speech if you favor certain speakers. So when the FAA, as a blanket matter, says, you can't fly drones, that's not singling anybody out for any particular type of treatment. But if the FAA says there's a flight ban for media drones only over Ferguson, Missouri, that looks like they're singling out speakers, and that starts looking a lot more like a First Amendment problem.
I don't see the reason why anyone would be upset that Columbian Park in the middle of Lafayette is just a drone-free zone, just as it was a model aviation-free zone in 1950 and 1960.
Yeah, so I think it's tied in. We're also at a particular cultural moment. Law often reflects what's going on culturally or socio-technologically around it. I think it also reflects that a lot of these conversations about recording and public accountability are taking place in the criminal justice system at the same time that drone regulations are being propagated. So you have people saying, like, I want to be able to fly my drone over Scotty Park. I want to be able to fly my drone over, the protests that are occurring in Ferguson. And it's resonating with these conversations about accountability of public figures like cops in a way that it wasn't necessarily before. Yes?
What would happen now if someone had a team of drones and they just kept one over you anytime you went outside?
Yeah, so
There's your companion drone.
So I didn't get into this too much in this presentation because it starts involving particularly strange / difficult conceptions of boundary management. One of the ways that you manage your social accessibility is that you deal with time, right? And you deal with how exposed you are to a particular individual over time. So if I have a relationship with one of my colleagues, in the office, I'm assuming that person only sees me when I'm in contact with them in my office. If they take a drone and they persistently follow me, none of my colleagues would do this, by the way, they're wonderful people, but if they took a drone and they persistently followed me, my relationship with them is disrupted. I can no longer rely on my ability to stop and start the interactions with them. So that's sort of the social psychology and understanding of like the privacy harm. As to what laws you can use, it's really complicated. There are stalking and harassment laws. There is a federal stalking law, but they have requirements of what sort of level of fear the person has to be put in order for the stalking law to apply, and they have intent requirements. So how it applies to that behavior will depend on how scared you are and how intentional the surveillance is. If it's conducted by an AI, is that intentional, right? Maybe? Whose intent? Yes?
So free speech and privacy can be looked at as a continuum. Like, the right to privacy can be looked at as the right to choose not to express oneself. So like in the example of, law professor dancing after getting out of the shower, that's sort of like, that person having the right to choose how she expresses herself and to whom to express that to. However, I have not heard of that that being used as a basis for a legal definition of privacy. And so I guess my question is, what are the problems with creating a legal definition of privacy based on the right to not express oneself? And if that definition could be created, what are the implications when it comes to emerging technology, especially filming or wiretapping or data collection and those kinds of things?
So that is an excellent question. First of all, I think that has been, this whole boundary management thing, and particularly this idea that you're saying of compelled speech, seeing privacy as entwined with compelled speech, right? If I am being recorded, I'm being forced to communicate something to people where I don't intend to communicate that. I think that's intuitively happening in cases. They just haven't named it as a privacy interest. So what I'm doing is naming, right? I'm identifying and saying, this is happening in a bunch of cases, it's happening in a bunch of laws, just nobody has said this is what they're doing. They usually justify it by it's sensitive information in a private place, et cetera. So I do think it's happening. I don't think it's out of key with practice. It's just out of connection with theory. And then what ends up happening to the laws is that you internalize the First Amendment interest, the speech interest, on the privacy side. So the First Amendment is an incredibly heavy hammer in the United States for very good reason. Like, we are a free speech emphasizing country, far more so than other countries. This whole European right to be forgotten thing has enormous free speech implications and probably wouldn't fly in the United States. So fly was not an intended pun. So when we look at privacy laws in the framework of the First Amendment, if we only think of the First Amendment as being external to them, they almost always lose. If we can say there's actually a free speech interest on the privacy side, either because I don't want to express myself widely, or, and this was in a Supreme Court case, because I won't have conversations if I know they're going to be distributed everywhere, right? This is why we have wiretap law. So I can have the private conversations and express myself knowing that it's not going to be distributed everywhere. That means that the privacy interest suddenly takes on some speechiness and doesn't always lose against the First Amendment.
And how does that apply to like filming someone or collecting sensor data or things like that?
The answer is it's contextual and it will depend, right? So that's the difficult part of all of this. So in terms of the kinds of laws we've been seeing with drones, you're going to have a court looking at, say, the Texas law, and saying the Texas law is expressing an interest in helping people to not be forced to express themselves. Well, that's pretty good, right? So that could potentially win against the First Amendment. But it's also targeting specific speakers and allowing oil pipeline people to express themselves and realtors to express themselves, and that targeting of speakers means, despite the fact that it's probably okay otherwise, it's going to lose because it's favoring particular speakers. Sorry, it's highly technical and contextual. We could talk more later. Yes? Oh, that's 5 minutes. Anybody else? Well, thank you all. I'm also available for private conversation afterwards. Thank you.